Hi, this is Gönenç Gürkaynak. I'm from Istanbul, Turkey. We're a law firm of about 90 lawyers, with 45 of them exclusively doing competition law in Istanbul, Turkey. I'm also a professor at UCL in London.
Yeah, Gönenç, a question to you. You are, of course, you have probably the best outside perspective on the EU. Because you are a lawyer, as you described at the beginning, located in Turkey, but you also have a very good insight, or have insights because of you are a professor in London. Do you think, from your outside perspective, especially if you compare what the horizontal guidelines, especially but not only in the field of information exchange, set out, do you think it's too detailed? Maybe it's too much regulation? Or would you say it's a role model for third countries? And maybe also considering what Bitten said, that she has to take it into account even when advising her business people outside Europe.
I wouldn't call it a role model, but I think it will be inspiring on many jurisdictions, including Turkey, but not limited to Turkey, in terms of the mode of regulation. So since 2011, we haven't seen this particular field regulated through guidelines, and I think the technique of regulating it is going to attract a lot of attention. The content, definitely, but there's nothing groundbreaking in the content. The content is playing it safe in the sense that whatever is now beyond doubt is being declared as we're ready to embrace it, and whatever is murky waters still is left out. So that technique is going to be noted, I think. And I think the authorities of, I'll call them peripheral jurisdictions without intending to be pejorative, that will be noted as a method of how to do guidelines. I think the regulators will have their eyes on the red zone rather than the green zone when coming up with their own guidelines. Red zone, green zone, meaning I think anyone who is learned in competition law reviewing this set of new guidelines will realize that while there's a huge appetite in expanding, say, the scope of by-object restrictions in exchange of information, there is not the same appetite in expanding the scope of safe harbors. So then the regulators outside of the EU will also note that it is better to be quite direct and explicit on what is the red zone, and it's not a great thing to tie your hands in terms of defining a lot of green zone. And it's also notable, I think, that the legal certainty issues in the stakeholder feedback to the new horizontal guidelines make it very clear to all of us that while private stakeholders are protesting that there is not enough clarity, especially on certain topics, some of them are saying JV to parent relationship in information exchange is not handled enough. Some of them are saying algorithms should not have been left out almost entirely. There's some optimization algorithms language in there, but it's almost entirely out. And some of them are saying other things that were their expectations and aren't addressed in the guidelines. As far as the public consultation part of it goes, i.e. the NCAs, the national competition authorities, giving feedback on legal certainty, they're super happy. And they say, this is great legal certainty, I know how to enforce and what to do. So that disparity, I think, is also going to be instructive for not only the likes of the Turkish authority, but for CAGI in Brazil, for very many authorities that have the infrastructure to enforce, like the Turkish Competition Authority, the infrastructure to enforce competition laws seriously, the history to do that, the know-how to do that, and yet is trying to follow the lead of some of the more mature jurisdictions of the world. No, I would agree. I also would add that it is quite frequent that business people lose track of what stops being okay in a process of molding of contact. So I'm following the lead of Bitten in the sense that you need to give them realistic scenarios of how it may evolve, what has happened in the future, how people have lost so, you know, it's always that, you know, there's the avian flu and the poultry manufacturers are in a room trying to address what this is going to do to them, and they're in panic. And in that process, someone starts offering too much information. It's never too obvious. So there's always a legitimate concern, or dyestuffs manufacturers are in a room and they're actually trying to teach the society, this is a Turkish example, to paint the outer banks of their homes as well. It's not in the Muslim culture or in the Turkish culture that you don't show off. You try to not show a good exterior. Once you enter into the house of someone, then it's heaven, but outside it's quite shabby. And that's not great for dyestuff manufacturers. So they're trying to come up with a scheme that this neighborhood in Istanbul is going to paint the outer skirts. And someone then raises a hand and says, yeah, but this is going to be famous, and the leading dyestuffs manufacturer will take the credit for it. How do we do? And then they start sharing information on how to handle this legitimate problem. The problem was legitimate at the beginning, but they basically go into a direction that is poisonous. So I guess in compliance programs as well, we always have to give them realistic examples of how easy it is to suddenly find yourself at the other side of the fence. So I try not to pull the Turkish competition lawyer card typically, but in a hub and spoke, I am very proud and glad to pull that card, because while many jurisdictions have only one or two examples of this, Turkey is the hub and spoke heaven of the world. And so I think I am the leading authority on hub and spoke matters before you today. And for those of you who are academically looking into hub and spoke, or who are interested in examples of what has been seen as hub and spoke, you really might want to look into Turkish examples. There are a lot of them. There's a reason as to why there are a lot of them, particularly in Turkey, and that already says something about hub and spoke to us and why it's so complex. So it was cute when Niccolo said high inflation, because that high inflation we eat for breakfast in Turkey.
Yes.
High inflation for us is 65% this year. It was plus 80% last year. And there is a decent competition authority that is independent and is trying to do its job in this environment. And because of that high inflation, there's constant changes of price. And so frequently this price changes, and so much communication is happening around it, that it becomes very difficult to handle competition law together with the need to switch to a new price in a country like Turkey. Also, combine with it the fact that we have very strong retailers in the country, and the manufacturers are very frequently weaker against these retailers. And the retailers have a practice of sending in what is called a difference invoice. And this difference invoice is a very delicate and interesting matter I'd like to highlight for you, which is basically saying, I learned that the following retailer had the opportunity to price its goods at the following price. I never had this opportunity because of your prices of selling me. Here is your invoice for the difference. You'll pay me now, to the manufacturer. And manufacturers, terrorized by this, would engage in communications, and there would be a lot of A to B to C communication, which is very easy to go astray. And that's why you have a lot of hub and spokes in a country like Turkey. So now switching out of the Turkish angle to it, but I thought anecdotally this would be intellectually interesting for all of you. The main issue in the guidelines now, going back to the guidelines about a hub and spoke, is that there isn't that much that is added, in my view, to the 2019 note that was given by the European Union to the OECD. And basically, it's seen as a type of horizontal collusion, closer to concerted practice, not so much as an agreement. And the case law, to the extent it is in its safest form, is mushed into what a hub and spoke would be. There is a platform example that's interesting. It says if a platform is preventing users from offering lower prices, then that's also going to be seen as an example of a hub and spoke. But overall, I think the most interesting bit in the example that is used in the guidelines is that it does recognize a goal. And the goal is to secure certain margins or price levels. Obviously, it doesn't say that if this goal cannot be proven, then there cannot be a hub and spoke, but at least we have some perception of why the regulator feels a hub and spoke would be happening. And I think my last note on this, without taking too much of speaking time, would be that in a hub and spoke scenario, it is now more and more becoming a part of the case law and the guidelines in general, that you need to be aware of the intent of the hub. So if you had a legitimate purpose in sharing the information and you had no means and there could be no reasonable expectation from you that you would be suspecting that there is an anti-competitive goal in all of this, then you could walk away free. This is a bit more directly recognized now in the current guidelines, in my view. The guidelines is actually helpful on this one. It does say, I'm paraphrasing, it's not exactly how it says it, but if it is in the context of a specific negotiation and the intent to lower the prices of your counterpart or to negotiate better terms is already inferable from the context of the contact, so long as that context is narrowly followed, the mere fact that the commercially sensitive parameter of a competitor is revealed by the reseller to the manufacturer in this example will not in and of itself constitute a by-object restriction. So we know this from case law, but it's good to see it written in the guidelines as recognized.
Yeah, maybe another topic that is interesting concerning the form of the information exchange is M&A transactions, where the guidelines now also provide for some guidance concerning the exchange of information, especially in a due diligence or in negotiations. The principle seems to be that any exchange of information that is not directly linked and necessary for the execution of the transaction might fall within the scope of Article 101. So it's a question of to what extent is it directly linked and necessary. The Commission also, I think, seems to believe that it depends on the stage of the point in time or the stage where you are already in the negotiation, in the transaction process, whether it's an early or a later stage. Now, how do you deal with that at your company in M&A transactions?
Again, this is not a revolution. I think it's hugely helpful that there now is something in the guidelines on M&A, because at least in my experience, I think this is one of the areas where there's been most divergence when you ask different law firms previously. There's really been very far-reaching ends of that scale on so the level of risk that law firms were prepared to take there. I think the description in the guidelines very much mirrors the thinking that we've done at our company. So I think, especially on the stages, I think that's that's just inherent in the way the process works. There's sort of a funnel of sort of the amount of information you can give in the beginning to a certain amount of bidders, and then as you move closer, you obviously also need more information. By the way, I don't think that only applies to M&A, also other forms of negotiations. There's sort of that funnel where you need ultimately more and more information in order to be able to actually close the deal. So I think this very much mirrors the way we've been thinking about it, also in terms of sort of when do you use clean teams, when do you use different sort of Chinese walls, etc., etc. But it's not an easy task. We actually spent quite a lot of time on it, and we have I have dedicated people in my team just working on M&A transactions and having sort of the teams calling them, can we share this? Can we share this? Can we share this? It's sort of a 24-hour day work when we have transactions on the move. So it's highly resource heavy, but nothing sort of new in it. So very much mirrors the way we're thinking about it. So at least that's beneficial that we now don't have to sort of have big fights with the other side now, that sort of, no, we can just share whatever.
Another question is in there, do you think there is maybe one part of information or one type of information that even in such a context cannot be exchanged? Because it is so sensitive, even at the date of signing, you cannot exchange it. Let's assume you have, I don't know, you have planned price increases or whatever. For it's a very easy example, maybe, but you have probably better ones. But that is really to be protected even at the very last day. Maybe also considering that, I mean, it's always also a question of, is it really necessary?
Yeah.
Is it necessary? Yeah. And if you think about necessity, okay, you can say, well, I need to have this information at the date of signing for certain reasons, maybe, let's assume that. But on the other hand, would it maybe be possible, and as another option, just to agree on a certain clause in your SPA saying, if this or that happens, I have the right to withdraw?
That's exactly the type of thoughts we're doing sort of every time we have an M&A transaction.
Yeah.
I think ultimately it's about, is it necessary? If it's something that's really impactful for sort of the company's valuation, you need it at some point. Then who can have it and under what sort of terms? Some things could also be managed by clauses. So, but then again, you also risk that the sort of the LTIs if you go too far into the company, right? So, so it's super resource heavy. This is not something that is taken lightly.
So the easier solution is then probably always just to use a clean team.
But that's not workable.
No.
Sometimes you just have that one person that actually understands what's going on, because some of it is really technical. I mean, I'm the best clean team because I don't understand anything, but I'm also the worst. Right? Yeah.
Okay. Any other views on that? Or?
I do think that there's a bit of a missed opportunity in this guidelines about this particular topic. In general, I do agree with the view of, keeping it to what you know and what you're comfortable with in preparing guidelines. But a topic like M&A and the safe havens that are required in M&A activity in terms of information exchange requires the recognition of M&A transactions not as a privilege of the parties contemplating it, but rather a necessity of scale in different markets. And so it is your duty to give better clarity, and the parties are actually going in with pure intent. So this is not a sphere of regulation where you start out with the question of why are you giving each other this information anyway? That tone will work in most other topics, but in the M&A context, I would think that the guidelines should have been in this, if you're coming out in June 2023, you should have been more aggressive in embracing the dilemmas facing M&A counsel and lawyers and in-houses and all the disparity in the legal advice. There is too little to work with. The stakeholder feedback is also mirroring this. When you look into the stakeholder feedback in the feedback sessions for the horizontal guidelines, there is a clear theme of protesting insufficient guidance and certainty, and this not being helpful on the field. So I think it could have been a bit more direct in giving more examples rather than saying case by case, we'll need to look into relevance and necessity. You know, we know all this, but this one was an opportunity, I think, to give a bit more of leeway for the entities, if that was the policy preference. My view is that this is a declaration that the policy preference of people preparing the guidelines is not one that wants to unleash the M&As and one that wants to keep people on their tippy toes, but that's a view on M&A transactions and what they do to the economy in general, I think.